Welcome to Vocational Expert Views channel. This presentation on the key barriers in MMTLP litigation. This presentation is coming from the perspective of a court evidence expert with extensive knowledge of securities litigation that will explain factually why every MMTLP-related court case since the December 8th, 2022, U3 Hall has resulted in denial of shareholder evidence. This pattern spans more than 3 years, with courts consistently upholding FINRA and SEC claims of immunity and labeling discovery requests as fishing expeditions. The core issue is the evidentiary threshold required under Federal Rules of Civil Procedure, FRCP 12B, 6, and 56, which demand plausible, admissible evidence of misconduct, e.g., fraud, bad faith, or ultra-various actions, to proceed beyond initial motions to dismiss. Without this, courts refuse to pierce the veil of immunity, as seen in repeated dismissals. We'll explore why courts have consistently denied shareholder evidence for more than 3 years, how FINRA and SEC immunity shuts down your claims, and the irreversible impact of the upcoming December 8th, 2025 data purge. This factual guide aims to help you grasp the challenges and consider alternative paths forward. As a court evidence expert, let's start with Part 1. Why have courts denied MMTLP evidence for over 3 years? The core issue is the high evidentiary threshold. Courts demand solid, admissible proof of misconduct before allowing discovery. The courts have evidence rules, and those rules are in the Code of Federal Regulations. Court is not about the truth, it's about what you can prove in court. Many people fail to understand this concept. So while MMTLP has high value statistically and based on common sense, when you put it up to the court's rules of evidence, it all falls apart. Courts are very specific on evidence. If MMTLP evidence does not meet thresholds of federal standards, without it, the court will uphold SEC and FINRA immunity and dismiss cases as fishing expeditions. This has happened repeatedly. Countless times for MMTLP court case, you also saw this occurring as in the Trot case, trapping shareholders in a procedural loop. The SEC and FINRA enjoy a double infinity loop of immunity. Even if you get past immunity 1 loop, you still have to win on immunity 2 loop. In 3 years, MMTLP has never gotten past immunity 1 loop. Diving deeper, specific evidence like FOIAs, despite revealing inconsistencies, fails in court review because it's unauthenticated and hearsay under federal rules. So while Congress, the Senate, DOJ, FBI can use that evidence in their decision-making, the court cannot. Broker statements from firms like Schwab are dismissed as not directly proving regulator bad faith. Courts agree with FINRA and SEC that using these for discovery is just fishing, leading to consistent denials across all cases. In short, all evidence that the MMTLP community can get fails court standards and therefore is useless on the legal front, which is why SEC and FINRA's immunity 1 loop has never been broken by MMTLP. The only way MMTLP will be able to get evidence the court will accept is if the court allows MMTLP to get it. In 3 years, it's never happened. It will not happen now. This is why MMTLP fails at court and will continue to fail. The court will uphold immunity. The FINRA FAQ, which explains the halt is protective, is rejected as non-binding and insufficient under Iqbal standards. So even though you have FINRA admitting to things in a public official written statement, and again you can use this to get public support, you can use it for Congress, Senate, DOJ, and FBI, but for the U.S. court system, the FINRA FAQ fails to meet Federal Code of Regulations for evidence. So it's no good. Materials posted on X, like timelines or tips, are seen as unverified anecdotes with no chain of custody. This allows courts to always side with regulators' fishing claims, ensuring evidence never advances in MMTLP suits. Again, the court will uphold immunity 1 loop that SEC and FINRA enjoys. MMTLP will never breach this castle locked by the courts.
Well, hello there, MMTLP. Shareholders, I am here to represent the SEC and FINRA viewpoints on you trying to get through the court system, so let's dig in, shall we? Now, from the perspective of an SEC and FINRA official here in Part 2. Here at FINRA we have absolute immunity protects our market regulation without litigation fears. It appears you forgot several years agone and won the bigger MMTLP court cases. We told the court our immunity protects us even if we don't follow our own rules, and our immunity protects us if we do something criminal. And guess what? The court's judge agreed. I guess you forgot that. FINRA immunity, it applies to halts like MMTLPs. It applies to everything we have done to MMTLP. We are the regulators and we rule. We get to decide how things play out and to ensure they play out so that the whole market doesn't get disrupted. You have to admit, in 3 years of not settling MMTLP, there has been zero disruptions to the market due to MMTLP. That is proof we did our job. That's what we are paid to do. You don't get it yet, do you? In order to broach our FINRA immunity, it requires you to prove major exceptions. First, which you cannot without discovery, we block that with immunity. So MMTLP, how are you going to get real federal court level evidence? We can block it and have been for 3 years. When we call it phishing, courts agree because rules limit broad requests, shutting down your evidence every time. Seriously, do you retail shareholders ever learn? It's okay. When we data dump in December, this game of going to the court will finally be done and over with. The market has moved on. FINRA only has to suffer your insanity a few more days, until we are finally free of your whining and complaining.
Greetings. I am here to represent the SEC, sovereign immunity, which really means we're untouchable without explicit waivers in Congress, Senate, nor the President is going to give you that. Here at the SEC, we have discretionary actions like MMTLP oversight qualify under our sovereign immunity. We make the rules and ensure what rules are followed and what rules do not have to be followed. Our job is to ensure market stability. It doesn't matter how we do it. The market is our responsibility, your little company, and your investment is not our concern. Our concern is making sure brokers can do their job. Ken Griffin and Virtu can do their job in providing needed liquidity and making sure they are fully supported in doing that. The market's needs, which means Citadel and Virtu's needs, come first. MMTLP and retail investors are last in line. It's always been that way. As far as the court is concerned, you need plausible proof to proceed, but immunity protects our records, which means there is nothing you can do to get them, which is why no one ever has tried. Courts always concur on phishing because your evidence, like FOIAs or posts, doesn't meet the specific standards, ensuring consistent blocks in all cases. The truth is you do not have the evidence, and it is our job to make sure you never get that evidence, and in a few days here in December we get to dump the data, so that is gone forever. Your days of bringing up court cases is numbered. It doesn't matter that you're not happy with how the SEC operates. It only matters if the market is stable and functioning, which it has for 3 years of your issue. That is proof we did our job. So when Congress or the Senate asks, all we have to say is the market stable? Yes. Okay, then we did our job, and that's it. Congress defers to us to keep the market stable, and we did that. The Senate defers to us to keep the market stable as well. As long as there is no disruptions to the market, it doesn't matter if you believe there was a disruption for MMTLP. The market rules.
Moving to Part 3. As a court evidence expert, on December 8, 2025, SEC, FINRA, brokers' records can legally be destroyed after 3 years. Brokers purge trade data. FINRA deletes halt blue sheets, CAT data, and other files. The SEC erases memos, trade data, and others follow suit if no court hold is in place. MMTLP, this routine spoliation, is allowed absent pending suits, making preservation critical now. If, that is a big if, you want some kind of bite of the court apple again in the future. If you don't stop this date, all the evidence you need that would meet federal regulations for evidence will be gone. Without this evidence, SEC, FINRA, and the brokers will be totally free from the MMTLP situation. There is nothing Congress or Senate or anyone can do once those records are gone. You'll have lost your last pressure point of chance.
After spoilage, even magical evidence won't work. It needs verifiable originals for court, which vanish. If destruction was routine, no penalties apply, leaving gaps that doom your case under best evidence rules. Immunity widens these holes, making litigation futile and exposing you to sanctions for persistent filings without new facts.
You might attempt filings 2 to 3 times with the court, with your evidence. But courts will eventually bar them as frivolous. Unless you have real evidence that meets the code of federal regulations, and you do not and never will. SEC, FINRA, the brokers will delete, and once data is gone, citing no recoverable proof. Residential judicata prevents relitigation, leading to sanctions like fees. This underscores why continuing the same fight post, 12/8/25, is ineffective. Consider constitutional redress, otherwise you got nothing left, it's all gone. In conclusion, MMTLP courts will deny your FOIA and other evidence and maintain SEC and FINRA immunity. Again, courts will deny evidence due to strict federal rules of evidence. Immunity protects regulators indefinitely, and data spoilage seals the fate after December 8th. Understand these barriers that the courts have and Congress and Senate have given to SEC and FINRA is basically a double loop of infinite immunity, and you have not even gotten past the first level in 3 years and 22 court case, sir. You have 1-0. If you were serious about whining, the only way is to catapult over the barriers of the courts and barriers Congress and Senate have set up. The only way to do that, pivot to constitutional redress to force change. Government only respects and works with standing armies. It's going to take in-person direct constitutional action. Otherwise, you're totally defeated.